Bat signal on Friday. The news is coming fast and furious, and we need a little primer. So Greg Willard, our go-to legal analyst, KTRS legal analyst and the St. Louis University Law School professor. Good morning, Greg Willard.
Good morning, McGraw.
All right, we originally asked you on the show to explain, and we'll start with that first, and then we'll get into all this Greitens stuff over the weekend. We'll sort of close one chapter before we open up another. On Friday, or I guess Thursday, it was announced that Josh Hawley, the sitting attorney general, issued a civil subpoena to the governor. I've never heard that phrase, civil subpoena. What does that mean?
Sure. Take a step back and just the basic concept of a subpoena. A subpoena is a legal process by which an individual or a company, a business, is required to either produce records or give testimony. You hear subpoenas being issued most often, McGraw, in the context of lawsuits.
Right.
We also hear from time to time disputes. I think there's going to be one today, in fact, in Congress, congressional subpoenas. So what it is, it's an order, it's a command to either bring documents, appear for testimony, or both. In this case, the Missouri Attorney General, Mr. Hawley, under the statutes of Missouri, he has subpoena power in certain buckets, if you will.
Right.
And he has issued what is called a civil subpoena, in contrast to a criminal. He's issued a civil subpoena as part of his investigation of the Greitens Group and the mission continues. Mm-hmm. I would not make much, if anything, out of the fact that he has issued a subpoena. The more important, I think, aspect is, as has been publicized before, the Attorney General does have an ongoing investigation of those entities.
So, I mean, is that just an extra word? I mean, he basically issued a subpoena for more information from these organizations.
Yes, it's one of his investigative tools to require those.
But is a civil subpoena different from a criminal subpoena, or is it just a subpoena? And
it's different in terms of the context in which it arises. So if you and I are involved in a lawsuit down in the city,
right,
and we want to subpoena someone, well, that will be a subpoena in a civil litigation.
Okay.
If Kim Gardner, the circuit attorney, wants to issue a subpoena, it's still a subpoena. It's just in a different context.
I'm trying to read between the tea leaves here. If Josh Hawley thought there was something criminally going on, he could have issued a criminal subpoena?
Well, if there was a suspicion that criminal activity, more likely, McGraw, it would not be a subpoena under one of those statutes. It would be a grand jury subpoena that whether it would be the prosecutor in Cole County,
right,
or a prosecutor, Kim Gardner, in the city. But it would be, I think, unusual in the context of a criminal proceeding. I think it would be highly unusual for the Attorney General to use his civil subpoena authority to pursue that investigation.
All right, let's get to over the weekend. A flood of news came out. You had Sheena Greitens' letter saying that the ex-husband cyber-stalked her. You have Greitens' team saying that Roy Temple tried to pay the guy to come forward. You have got them trying to throw out the Confide app. You have Greitens' team going one more time to the House committee saying, hey, please hold off on this. What's going on?
I was reminded, I'm glad you used the flood analogy. I was reminded of that line in the movie, Absence of Malice. The last time there was a flood like this, Noah built himself a boat. I think what's going on, if we can dare read the tea leaves,
right,
is I think this is driven largely, McGraw, by the impeachment process. Maybe I'm wrong,
right,
but you and I have talked on the air that I personally believe that the impeachment process presents a significant risk to the governor. The fact that, by all reports, the committee that the House empowered to investigate the impeachment piece, by all reports, that committee is going to issue its report this week.
Right.
And I don't think it's coincidence that we have the letter from Ed Dowd, the governor's criminal defense attorney, come out on Friday. We have the letter from Mrs. Greitens, of all people,
Right.
Was leaked yesterday. And now we have the Mr. S. His counsel, Al Watkins, was on was on your show this morning. I think all of this cacophony, McGraw, is driven in large part by the impeachment committee's report, which is about to be issued.
And that's why you're on, because there is sleight of hands going on. There's a giant magic trick going on, right? Don't look at this hand. Look at this hand over here. So that's why I wanted you on the show, because there's what's going on in the city of St. Louis, which there may or may not be a picture. There may or may not be some felony charge. There is a felony charge, but he may or may not be guilty. He may or may not be innocent. Who knows? But everyone I talk to, including you, say what's going on in Jefferson City is the bigger story. It might be salacious and cocktail talk about the sex, but it's what's going on in Jefferson City. And so this is important stuff. And you mentioned this a couple weeks ago, and it was so important, and so few people understand this. I want to go through this again.
Sure.
You say that in Missouri, it's a low threshold to impeach a sitting governor.
Yes.
So
very low.
Explain that, and explain this report that's going to be released. Whatever it says isn't necessarily going to talk about crimes that were committed, but it's going to be all the dirty laundry about everything. And so explain the threshold part of this impeachment, because that's where I think this is going to get interesting real fast.
Sure. To sort of set a baseline, McGraw, if you or I were a public official subject to an impeachment inquiry in the United States, Missouri is one of the last states we would want to be in. In Missouri, and let's talk about a governor impeachment, but it would apply across the board. But in Missouri, a governor can be impeached for, among other items, misconduct. A governor in Missouri can be impeached for something that is not a crime.
So misconduct being whatever they deem it to be at any given day.
Yes.
Okay.
So we start with that it's not, as we learned in our 8th grade civics class, McGraw, when we studied the U.S. Constitution, where it's treason, bribery, or other high crimes and misdemeanors. Missouri has a much different set of standards, and one of them is simply misconduct.
Okay.
Secondly, is once a governor is impeached, unlike in most states and unlike in Congress, the governor is not tried by the Senate, because we can recall in the Clinton impeachment, and then Senator Robert Byrd very pointedly said, and I think lots of senators subscribe to this, the vote in the Senate at the trial is a dual. It is a vote to convict and then separate vote to remove. That is not the case in Missouri, McGraw.
Okay.
The trial, if the governor is impeached, will be by 7 judges that will be appointed, esteemed jurists. The Constitution,
state senators.
By the Senate will appoint 7 quote esteemed jurists, and they will try.
But those 7 jurists will come from state senators. They'll come
they will come from jurists. So I think if
just like citizens.
Well, no, I think it would have to be a judge.
Okay.
A jurist being a
So they'll
judge.
find 7 judges, and they'll ask these 7 judges to sit on this.
And they will preside over the trial to convict. And again, if you and I were a public official being impeached, fasten our seatbelts, because this is not pretty for the accused.
Right.
Number 1, it is not unanimous. 5 out of 7 can convict.
Okay.
Number 2, the standard of proof that has to be shown is not, and you're a fan of the Law and Order show, McGraw, it is not beyond a reasonable doubt. It is this substantially lower standard of clear and convincing evidence. And number three, what those judges who sit as the triers at an impeachment trial, they have a very simple question. Did the impeachable conduct as alleged occur? And has that been proven by clear and convincing evidence? They do not, and the Missouri Supreme Court has ruled in this, and the Judith Moriarty impeachment, they do not say, well, and we are going to make an independent judgment as to whether that conduct is so egregious that the governor should be removed. All that the trier in a Missouri impeachment decides is, were the allegations of the articles of impeachment proven? If the answer is yes, that public official in Missouri is removed.
You had to go to the back page of the law book for this one, didn't you?
We dug deep, but you know, I always got to take care of my friend on the air.
Holy mackerel! This is the back. This is the back. This is the last page.
Well,
okay.
it is the back page for two reasons. Number one, we haven't had a lot of impeachments in Missouri, McGraw. But number two, Missouri's impeachment paradigm is so unusual compared to the other states,
right,
that when you go back to the back of the book, so to speak, and you look at it and you say, wow, this is not where an official accused of an impeachable offense, misconduct, for example, this is not the state where that official would want to be.
Okay, so a couple of things here, which politics is going to rear its ugly head everywhere. One, the Senate decides who these 7 jurists are.
Yes.
Are they on the federal courts? Are they state judges? Are they county clerks? Are they? I mean, what could you be? You're not a judge. I mean,
no,
could Katy Perry be on? I mean, what's the baseline for the judge?
I think we have to take the Constitution, as Justice Scalia would say, read the words, and the word is jurist. Now, it doesn't say state or federal, but I think as a practical matter, you would never get a federal judge to agree to sit in a state impeachment.
Right.
So I think we can safely assume, McGraw, that it will be 7 state court judges, either circuit court or
and the Senate picks those,
or Court of Appeals, or I guess in theory it could be one of the judges on the Missouri Supreme Court.
I mean, they could stack the deck any way they wanted to, though, politics-wise, right? I mean,
they could. They could make an assessment that if it's let's say hypothetically, it's a Democratic governor, and they could say, oh, well, we're going to pick seven former Democratic county chairs who are now judges in some county.
All right. So this report that comes out, Al Watkins said on the show earlier today that he said it for the first time publicly that I know of, that the ex-wife said that Greitens slapped her and verbally abused her. If that's deemed misconduct by a governor who wasn't the governor at the time, but let's just say for argument's sake, they deem that to be misconduct. And that is the charge. The House would rule, is that an impeachable offense?
Yes. The House, you summarized it well, McGraw, and I think it's important for our listeners. What is an impeachable offense is as decided by the Missouri House of Representatives. And if they decide that a collection of conduct, whatever that may be, but the House says, we make a judgment that this conduct is an impeachable offense, then they will hand up an article of impeachment. It will go to the Senate, and then we'll proceed with the trial by the 7th.
The House says, yes, one of the things is he slapped her and he verbally abused her. That is unbecoming of a governor. The House passes it. It goes up to these 7 judges. The only thing you're saying these 7 judges will say is there enough evidence to support that he slapped her? Yes. There's enough evidence, regardless of whether they believe it's an impeachable offense or not.
Exactly. Is the question at that trial is, did the House managers, who would prosecute the impeachment, did they prove by clear and convincing evidence the conduct as alleged in the articles of impeachment? And if 5 say yes, then that public official is removed.
Okay, I'm short on time here, so keep your questions short because we only have so much time in this class because I have to get to the next one. The timeline here, everyone's looking at the city criminal case, but you have this investigation, plus you have Josh Hawley's mission continues investigation. So how does this report come out before Josh Hawley's finished with his?
Well, I think we have several different buckets. You've got the mission continues, you've got the Greitens group, you've got the prosecution, you've got the Confide app, and you have the impeachment. While some of those dots are connected, I think it's important, as we've talked on the air, McGraw, those are independent cases, and they will go on independent timelines.
He might survive this investigation, but the next one, when Josh Hawley comes down, he might have to go through this again?
The jury in the city may come back and say not guilty.
Right.
And the House of Representatives may say we are going to impeach him for the same conduct for which he was found not guilty by a jury. And McGraw, as a matter of Missouri constitutional law, that is 110% appropriate. Whether you agree with it politically or otherwise, that constitutionally would be appropriate, notwithstanding the acquittal.
Greg Willard, keep your cell phone on. We're about to enter a vortex, is what you're saying, right? This is about to get hairy.
Fasten your seatbelt.
Greg Willard, a professor at St. Louis University Law School.